A very good afternoon to all the dignitaries present here and participants. And at the outset, I would like to congratulate and thanks Professor Martin for uniting us all together for combating this madness of this common crime, hate speech. Thank you so much. And while Justice Lokur has already set the tone for this session, so I would be taking this discussion further. And Medha has already explained certain terminologies, so she has already given me the background, so things would be easier for me, so I don't need to dwell into explaining certain terms to you. So I would also be skipping, due to the paucity of time, I'll also be skipping certain things which have already been discussed by the presenters, and I would be directly taking you to the judicial approach while adjudicating the religion-based hate speech cases. But yes, as we have discussed that in India, there is no definition of hate speech, and it's not India. Universally also, there is no agreed definition of hate speech except the common understanding of its core components, that is the malicious expression of hatred against person or an idea that causes harm. And over the years, so far hate speech is concerned, it has definitely, its ambit has got broadened. It's including whatever is discriminatory, derogatory, insulting, offensive, that's resulting in violence. And over the years, it has emerged as a serious hate crime, resulting in physical attacks on victims in the form of mob lynchings, causing chilling effect on the freedom of speech and expression by resulting in exclusion from democratic process and public discourses. So, taking you directly to the judicial approach, as Sir also mentioned that in India there is no, we don't have any consolidated legislation to deal with hate speech crime. But yes, there are a lot of provisions from the IPC which are being attracted for the purposes of hate speech. And in consonance with the theme of my paper, I would be dealing with section 295A, that's talk about the deliberate and malicious acts to outrage the religious feelings. And along with section 295A, most of the time it's section 153A that has been invoked, that's promoting enmity and hatred between the communities. Yeah. Now, so far, hate speech is concerned, it's a very live debate in India, and the shared feared concern in India is that defining hate speech may prove to be counterproductive to the freedom of speech and expression. And it is this fear that has prevented judiciary from defining hate speech. However, while adjudicating the cases related to hate speech, the Indian courts do refer to the various principles, tests that have been approved and acknowledged by various courts, national and international, for the purposes of determining what are the permissible limits of the free speech and in order to distinguish it from the hate speech. Now, some of the tests which we can see here is that incitement to violence, incitement to discrimination. Sometimes speech may not incite violence, but it is having a tendency to marginalize some section of the society. So incitement to discrimination is another important factor to determine hate speech. Then public order and reasonable restriction. So far public order is concerned, in India, the state imposes restriction mostly in the interest of public order in hate speech cases. But so far, this expression in the interest of public order is concerned, it's a very wide expression and includes any act which is likely to cause breach of public order. But I would like to say that over the years, this test of public order and reasonable restriction has been rationalized. And today, it is no more confined to simply an act which is likely to cause death, but the courts have emphasized that there needs to be a proximate link between the speech and the public disorder. It should not be hypothetical, it should not be remote, and the expression must be instinctively dangerous to the public order. Then we have content, context, and intent test, which is widely been accepted, used by the Indian courts for the purposes of distinguishing offensive speech from the hate speech. Then we have the reasonable man test. But so far reasonable man test is concerned, what amounts to a reasonable man, we do not have a definite standard, and which brings a subjectivity in the adjudication of hate speech cases. And this can be seen more when hate speech is based on religion. Then we have presence of two communities test. There must be one community targeted one and the another which incites violence. Then test of necessity and proportionality. Every restriction that has been imposed needs to have a backing of law, needs to be having some purpose, there must be a necessity of such action, and it must be proportional also. In addition to the above mentioned tests, the courts have always subjected the satisfaction of the executive has also been put to the scrutiny by the courts, because there have been numerous occasions on which the executive authorities have found to be functioning under the influence of the political organizations. And in such scenario, in order to protect the individual freedom, individual rights, and in order to prevent the abuse of the powers, the satisfaction of the executive is also being subjected to the scrutiny by the courts. And it's no longer res integra that the executive scrutiny is not immune from the judicial review. Now, since I told you I'm more concerned with section 295A, which is talking about deliberate and malicious act outraging religious feelings, before I get into the judicial approach, I would like to highlight the lacuna which I see under section 295A. So far, section 295A is concerned, it's cognizable offense where police can arrest without warrant. It's a non-bailable offense. And most of the time, it has been seen that this section is being invoked in an arbitrary manner. Many authors, scholars, academicians, they all have borne this burnt of this draconian provision. And this section does not define what kind of religious sentiments are being protected. So a very important question, and what amounts to religion for the purpose of this section? So far, this term religion is concerned, even the Supreme Court has said it's very difficult to come up with a very precise definition of the term religion. But a very important question that arises is that what this word religion includes Hinduism? Because, calling Hinduism a religion is also very debatable, that in the view of Supreme Court's own decision in 1996, that was Ramesh Yashwant Prabhu's case, where Supreme Court said Hinduism is not a religion, it's a way of life. But I believe every religion by its nature is a way of life. So attributing this fundamental characteristic to Hinduism, the courts have tried to create an artificial inequality amongst the equals. And further, there is also a question whether this Hinduism includes within itself other religions like Buddhism, Christianity, Islam, Sikhism, or it assimilates countless sects. That's another issue here. And this section does not define the threshold of insult. So, often making a distinction between criticism and insult, scope of fair criticism is being narrowed down. So I find this section 295 very vaguely worded. It leaves the scope for unwarranted space, risk of non-uniform application, and judicial inaction as well as overreach. Now, so far this section 295A is concerned, it was never been a part of IPC. It was just added to our criminal law later on. Our IPC is 1860, and it was added by 1927 because of the conflicting interpretations of section 153A. So it was realized that there was a need to have a section that was dealing specifically with the outraging the religious feelings. Now, invocation of section 295A, often it is seen that it's been invoked on the grounds whatever is seen distasteful by the government. Many times it's been invoked on flimsy grounds, on frivolous reasons without any legal backing to substantiate the arguments. And most of the times this religion-based hate speech has got so much deeply ingrained in our society that there have been countless statements made by the people against the religion of the others, and capturing headlines most of the time, followed by the violent clashes, mostly, I will not say exclusively, mostly between the Hindus and Muslims. And if somebody looks at the NCRB data, that's a National Crime Record Bureau data of 2020, one could see that during 5-year, 2015 to 20, there is a 4-fold increase in the number of cases registered under section 153A. These two sections are often attracted together. And However, the conviction rate is very less, that is only 20.4%, and year 2020 witnessed maximum cases of promoting enmity between the groups, that was 1,804, which almost was 70% higher than if we compare it with section 2019. So it's increasing day by day. Now coming to the judicial approach. Now, whenever the cases of religion-based hate speech come before judiciary, judiciary in some cases have shown a very, very pragmatic approach. They have dealt with the issue, serious concerns, and they have realizing the urgency and gravity of the situation, they have acted very efficiently and promptly. But there have been cases where both High Court and Supreme Court, they have failed to take a desired route, and they did not come up with any prompt action. For instance, there was a case which required suo moto cognizance by the court. That's a Dharam Sansad's case, which Medha also referred and Sir also referred, where a call for genocide was made in the name of protection of Hinduism. But in this case, the Supreme Court failed to exercise its mandate envisaged under the Constitution. A letter was written by the lawyers of the Supreme Court. 76 lawyers wrote the letter drawing attention towards state inaction, drawing attention to the fact that even after registration of FIR, no arrests were made for a period of 1 month. Though the court in the preliminary hearing of the petition that was being filed by one journalist, Qurban Ali, the court gave directions to the state, but the court's hesitance to intervene was very clear from the opening remarks of the Chief Justice that there are penal laws, there are enough laws, what law we can lay down now. So similar was the situation in another case, that was a Delhi Doit case, where another activist, Harsh Mender, he filed a petition before the court for the purposes of getting the FIR registered against certain politicians who delivered hate speech in context of Delhi Riot 2020 riots. Now, when the matter was before the High Court, frustrated by the long adjournments given by the High Court, he approached Supreme Court, but the Supreme Court also refused to hear his transcript, also did not allow his lawyer to argue. So frustrated by this entire futility of the process, he withdrew his petition. The case is still pending before the courts. And then there is another case of Sudarshan TV news channel case, where one show with an object of exposing Muslim community penetration in civil services, titled Bindas Bol, creating hashtag UPSC Jihad, Jamia Jihad, was being announced to be telecasted. A petition was filed before the Supreme Court to put a ban on the telecast of this program. But the Supreme Court initially did not find any favor in granting ban. But later on, when the show was telecasted, and when the Supreme Court itself saw the clipping of 49 seconds, Supreme Court 3 judges came to the conclusion that the object, intent, and purpose of the show was to vilify the Muslim community. It was a scurrilous attack on the Muslim community. And then the court put a ban on the telecast of the remaining series of that particular show. But if I compare this with an approach that was taken by the Supreme Court in one of the case of state of Karnataka versus Praveen Thogadia case, which Sir also referred, where a leader was banned an entry in the communally sensitive areas, and that was justified by the Supreme Court by adopting the theory of basic structure. The court justified preventive action on the ground of preventing person or group of persons from promoting enmity. Similar kind of approach could have been taken in Sudarshan's case also, but that was not being taken. So if initially this action would have been taken, this would not have promoted enmity between the communities. So you can see from these cases that how these cases are reflecting that there is a significant procedural and substantive asymmetries when the cases are being adjudicated by the judiciary pertaining to the religion-based hate speech cases. Then we can see that there is another inconsistency that can be seen in the approach of the courts is regarding the application of principle of exhaustion of alternative remedies. Generally what happens is that writ petition, whenever hate speech cases come before the court, most of the time people file writ petition before the Supreme Court under Article 32 of the Constitution. The law of the land also provides for an alternative remedy of filing writ petition before the High Court under Article 226 of the Constitution. And Supreme Court has also laid down in numerous cases that one should approach the High Court first. But despite of this, one can again see a lot of inconsistency in Supreme Court's own approach that could be highlighted through these three cases. Nupur J. Sharma's case, where FIR was filed against the reporters of Op India, a news web portal, for reporting violence at some place. So when they approached Supreme Court not only stayed the investigations, but subsequently also quashed the FIRs. It's very pertinent to note here that, I said that people usually file, generally people file writ petition before Supreme Court, though we have an alternative remedy of filing writ petition before High Court also. But at the same time, existence of alternative remedy is never a bar. It's just a self-imposed restriction. But Supreme Court has also said in numerous cases that one should approach the High Court first. But in Nupur Sharma's case, Supreme Court not only stayed the investigation, but it subsequently quashed the FIR also. But in the another case of Dr. Kafil Khan's, Nazrat Parveen's case, when Dr. Kafil, he was detained for alleged hate speech on the recently enacted the Citizenship Amendment Act in Aligarh Muslim University, and he was detained. When his mother approached Supreme Court for his release, Supreme Court asked her to approach High Court. She moved before High Court applying the test of public order, that there was no proximity between the speech and the public order. The court applying the content, intent, and purpose test, which I just mentioned in the beginning. The court said that the purpose of the speech was not to promote any enmity. Criticizing the district magistrate for taking a very narrow approach of just focusing on some of the passages and not looking at the whole of the speech. High Court set aside the detention. But, one can see that in these two, when comparing these two cases, the courts needs to exercise their extraordinary power in a very efficient manner, which seems to be lacking as of now. And in contrast to these two cases, which I have just referred, in another case, Amish Devgan's case, where a journalist on his show, R-Par, he referred to Saint Moinuddin Chishti as an attacker Chishti, looter Chishti, and a lot of FIRs were filed against him. He approached Supreme Court for quashing of the FIR. Supreme Court in this case did not granted him the relief which was claimed by him, but ordered for the consolidation of various FIRs which were filed against him, and also granted him interim protection till the time he was cooperating for the investigation. Now here you can see that Supreme Court did not ask him to approach High Court. Supreme Court not only got into the merits of the case, got into the in-depth analysis of the hate speech, came up with a comparative jurisprudence, looking into the precedents already there, said that the effects of the words is to be seen from the mind of a strong, reasonable man, not from the weak person who senses danger in every hostile point of view, saying that the persons of influence, the court also observed one very important observation made in this case, made a very important observation, that persons of influence like top functionaries, government functionaries, executive functionaries, TV anchors, political leaders, social and political leaders of following, they, because of their reach, impact, and authority, they carry very much lot of credibility than the statement made by any public person on the street. So the court came up with the this test of person of influence in this case. But at the same time, with these observations and this holding of the court, there was a lot of ambiguity that was surrounding around this observation of the Supreme Court, because the Supreme Court did not make it clear what would be the quantitative test to determine who is a social leader of following. Does it mean social media follower who's having a lot of following on the social media? So there was no clarity, and it was a concern of many that accounting, very high accountability may lead to malicious prosecution against those persons who frequently raise their voices against the public opinion, government policies and actions. So these were the concern, and the result of this ambiguity, which could be seen in the Devgan's case, was very much apparent in Madras High Court decision. In two similar cases, Madras High Court came up with the different decisions. One is a case of Mary Dawes versus state represented by Inspector of Police, where a YouTuber posted on his video that the Muslim terrorist, they spread coronavirus. That was in the context of the Tablighi Jamaat that was being organized by the Muslims, that the Muslims terrorists deliberately, they spread coronavirus because they wanted to kill the innocent people around the world. So when FIR was being filed against him, matter came before the Karnataka High Court, Madras High Court. Madras High Court quashed the FIR on the ground of saying he just spoke whatever was there already in the public domain. So it was, and this kind of criticism of religious denomination could not be considered as a criticism of religion. So the court distinguished this case from who, what, where. That was laid down in Amish Devgan's case, not holding him as a person of influence. But in contrast to this, the same Madras High Court, in another case, that's George Punaya. So in this case, the court, when FIR was filed against one Catholic priest for his statement against the BJP MLA, that he can walk barefoot, but Christians cannot, because otherwise the filth of Bharat Mata will contaminate them, and they will catch scabies. So when the matter was before the High Court held that by representing Bharat Mata as a source of filth and contamination, he has tried to represent Bharat Mata in a very offensive manner, and considering that Catholic priest as a person of influence, the court refused to quash the FIR against that Catholic priest. So one can see the inconsistent approach, and that's because of the ambiguity that is surrounding the interpretation of the hate speech. And this is the reason, I said, most of the time it's section 295A and 153A is attracted. And it's been witnessed that how the section 295A is being abused, read, reread according to the court's interpretation and the administrative whims and fancies. Now, taking you towards the literary and artistic academic works also, where the cases come before the courts pertaining to the hate speech. Though so far academic and literary works are concerned, the courts have always tried to maintain a balance between the internal factors and external factors. Internal factors, tone, tenor, language. External factors, is there any already atmosphere of violence or disturbance? And so far academic works are concerned, they are also being protected. So far the language is not crude and cursive. But despite of that, there have been many instances where the academicians, artists, they all have been, they have all borne this brunt of this draconian provision, as I was highlighting earlier also. And this shows the lack of judicial proactive oversight over those cases. And there are many instances. Sir was referring to Manwar Farooqi's case. He spent 37 days in jail before he was granted bail by the Supreme Court. So, similar was a case with another comedian, Kiku Sharma. He just mimicked mimicked somebody, and he was being sent to custody for 14 days. Though later on, Haryana government, they quashed the FIR. But that's how the people are becoming victims of arbitrary invocation of section 295A and lack of judicial oversight over such cases. Now, in literary works also, one can see inconsistency of judiciary due to the lack of clear standards to determine the relevance of the context, and consequently, from recognizing right to criticism, the courts have narrowed down the scope of religious debates. Now, how the courts have narrowed the courts, now what one can see in context of artistic, academic and literary works, One can see that so far right to criticism is concerned, the courts have unanimously held that inserting paras, paragraphs, they always need to be seen in context of the entire theme of the book. They needs to be read as whole. But where comes the variation? Variation comes in validating the procedure for forfeiting those works. There have been cases where different approaches have been taken by the courts for the purposes of validating those forfeiture, as one can see in case of Veera Brahmam, state of Andhra Pradesh, where a book titled Bible Bandaram was an issue. And the state government forfeited it by just citing the passages from the books in the notification. You know, for the purposes of forfeiting any published work, the government has to come up with a notification mentioning grounds in that notification. But in that case, when the state government just cited the paras in the notification, the court upheld the ban, saying that it was validly forfeited by the state government and there was no need for the grounds to be mentioned, citing paras is sufficient. While in another case of Lalai Singh Yadav, a different approach was altogether taken, where another book, Samman Ke Liye Dharam Parivartan, based on B.R. Ambedkar's speech was an issue. The court said the forfeiture was that the court upheld, did not upheld the ban, but at the same time the court was of opinion that citing passages in the notification is not sufficient. There is a need to mention the grounds, and in that particular case the government did not mention the grounds, it just cited the paras. The court said that this ban was not valid. So one can see that how there is an inconsistency in the procedure of validating the forfeiture. Then similarly, but however, at the same time, we can't deny the fact that the judiciary has always been very pragmatic in recognizing this right to criticism, as can be seen from various judgments, like Patrika Mokhim's case, state of Meghalaya, where she spoke about the attack on the non-local tribal youth, but the comment and FIR was filed against her, but the court said that mere disapprobation of the government policy can never be considered as an attempt to outrage religious feelings. Similarly, in Fida Hussain case, when his painting was challenged on the ground of obscenity because he painted Bharat Mata as a nude woman with flowing hair forming Himalaya. So this was being challenged on the ground of obscenity. The court, applying Hicklin test, said a work cannot be considered to be obscene. It needs to be seen as whole. It needs to be seen from the perspective of the painter. And in this painting, he just represented India being entangled into various evils of illiteracy, poverty. So there was nothing wrong with this painting. So the court quashed the FIR against the Fida Hussain. Similarly, in another case of Sujato Bhadra, in this case also, when she wrote in her book about how after Islam became the national language of the religion of the Bangladesh, the Muslims women were not independent, they were mistreated. In this case, again, the court held that if the author is writing something in good faith with an object to facilitate social reform by administering a shock to the people, then such work should not be regarded to be insulting to religious feelings. So one can see that how the court came up with a pragmatic manner. Now, so similar kind of instances I have mentioned, because over the years, Section 295 has also been attracted against the historical figures, which by no stretch can be considered to be the religious figures, as one can see in Sanjay Leela's Bhansali case, when FIR was filed for putting ban on the release of a movie called Padmavati, which was based on the life of Padmavati. So she was a historical figure, not a religious figure, so the court quashed the FIR. Now, narrowing down how the courts have narrowed down the scope of criticism, there have been so many cases where the courts, while giving orders, they are not coming up with reasoned orders. And the courts, by not coming up with reasoned orders, are indicating that they are not considering rights as trumps, but they are considering it as an abstract notion that lies at the behest of the state. Now, so coming to the conclusion, we can very well see that how there is an inconsistency in the approach of the judiciary while adjudicating hate speech cases, but at the same time, judiciary has tried to maintain a balance also. But yes, there is a need to minimize executive discretion, which can be done by introducing judicial scrutiny at the very initial stage. There is a need for coming up with a time frameworks for various procedures, various state proceedings. It will ensure accountability and bring more transparency. There is a very important suggestion which I just want to make is that there's a need to have an internal high-power committee that is consisting of top executive functionaries and retired judges of High Court and Supreme Court, so they can really analyze the material that has been brought before the court in hate speech cases. And since this, as I said, these offenses are non-bailable in nature, so the legality of the preventive action can also be taken, assessed by this internal committee. And last, there is a need to have a special legislation for the purposes of regulating this hate speech propagated through social media. Though very recently we have come up with Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, but these rules are then got challenged before in various petitions, through various petitions before various courts on the ground of being discriminatory and violating privacy. But yes, we can have such laws, drawing inspirations from the laws internationally already there. So if these suggestions can be taken, so I think we will be, to some extent, will be able to curb the menace of this hate speech in India. Thank you so much.